going on? How's everyone doing?
Shout out to Colin. Everybody else who's cool with Colin.
Chunky! I didn't say.
Eat your popcorn and your Coca-Cola and relax.
Anyway, tell Colin I'm ready.
What's going on? This is Colin. How's everybody doing? I hope you're having a great day so far. Oh, I've got a jury trial. This is a pro se jury trial in front of Judge Clark. This is out of the Bay County area in Florida, and it's a good one. It is a good one for everyone except for everyone in the court. It's a good one for us to watch. Oh, man, it's a frustrating case, though. The charge, it's a simple possession charge. Possession of methamphetamine. She decided to not have an attorney, take it to jury trial. I honestly think she just did this because she had nothing else to do. But this is exactly how you think it would be for a pro se in a jury trial. And it's kind of funny at the same time. I really hope you guys enjoy it. I did cut this down from a 3-hour-long video to about an hour and 20 minutes. So this will be a little bit longer than normal. I will keep my pauses to a minimum. At least I'll try to. No promises, though. You guys know me. All right, before I hit that play button, you know what to do. Hit the like and subscribe. Do your jump kick backflips. Let's go.
At the Bay County Courthouse, Courtroom A, State of Florida versus Tanya, Tricia, Ellen, Tony. And I think we're going to trial on case number 23 CF 1251. Is that correct?
That's correct, Your Honor.
On just one count of possession of methamphetamine?
Yes, Your Honor.
For the record, Ms. McAfee is present. Assistant State Attorney prosecuting the case. Ms. Tony's present. She's representing herself, and we'll go over that in just a second. Ms. Tony, I can see that you're not dressed out. It's my understanding that you didn't have some clothes that were brought and you decided not to dress out.
Yes, sir.
All right, Ms. McCarthy is present. Ms. McCarthy, did you bring clothes today?
Yes, sir. Yes.
So you understand you do have clothes to dress out on?
Yes, sir.
You understand that you have a right to be dressed out?
Yes, sir. My family was gonna bring clothes. I didn't know I had to be on the same day. They tried to bring them yesterday, and I was super cold in that, and I couldn't concentrate, so I just
You
hoping
understand?
for the best.
You understand that the jurors
Yes, sir.
don't have to know that you're in custody, and it may prejudice you if
Yes,
they
sir.
know that you're in custody.
I want them to know I'm still in custody. Yes, sir.
Okay. Well, that's not something we're gonna talk a whole lot about. You understand that?
I mean, I would rather than know I'm in custody than think I'm free.
Okay.
Yes.
All right. But you understand you have a right to be dressed out. Ms. McCarthy has brought you clothes. And that you
Yes,
can
sir, I
be dressed
understand.
out. Okay, you understand you have a right to be represented by an attorney.
Yes, sir.
And in any stage of these proceedings, you can ask an attorney to get appointed to represent you. Mr. McCarthy is ready and is available for that appointment.
Yes, sir.
Do you still wish to represent yourself?
Yes, sir.
Right. You understand that Mr. McCarthy is trained in the rules of evidence, criminal procedure, and the law. He's already tried a case this week, as a matter of fact. But you still wish to proceed?
Yes, sir.
All right.
I do have one question.
Yes, ma'am.
Am I allowed to let the jury see a paper of mine?
I don't know what it is.
Can I show you?
You gotta show the state first.
Okay. It's just a notarized paper.
All right. Well, there's a little bit of dead air. Nope, no dead air.
No, ma'am. You absolutely can't say any of this. You can't tell the jury.
No, I can't let them see that?
No, ma'am.
Can they?
No, ma'am. And you can't let the jury know what potential sentence will be. You can't tell the jury that you're looking at 5 years in prison. They cannot know that. You don't know what you're doing. And you're competent to represent yourself, and I have found you competent. I'm gonna hand this information back to you. You cannot file that. I've already dismissed your motion to consolidate. I need to accomplish that. But you cannot let the jury know that what you're looking at, a potential sentence at all. You understand?
Yes, sir.
Do you still wish to represent yourself?
Yes, sir.
Any other questions you have?
Why would I be allowed to show them this?
First of all, you've written on there how much.
Okay, what, can I
No,
bring
ma'am,
it out?
there's nothing on that that's relevant. You can you can call yourself as a witness.
It is, because there,
No, ma'am, I
it's a
don't argue.
notarized copy.
It doesn't matter. Don't argue with me. You're going to be held to the same standard as a lawyer. I wouldn't have a lawyer argue. They can make an argument too. That's not coming in. You can testify, but you waive your right to remain silent if you do testify.
Yours connected to that?
It's connected.
Just make sure it's in there all the way.
All right, I have no idea what's going on with Judge Clark's computer.
Or anything else?
It keeps dinging. This is
Ms.
Florida.
Tony?
No, sir.
Ms. McAfee?
No, sir.
Did you file an amended information?
I believe Mr. Sullivan filed an amended information to the one count of the site.
It should have been filed,
It's filed.
jury selection.
All right, and that's an amended information. Ms. Tony, have Ms. Tony, give Ms. Tony a copy of that.
So does that mean I can't say that I was booked in the 2 counts?
I don't know what relevant that would be, but we'll see. You'll have to just try it if there's an objection. There's the information. Do you wish to enter a plea to that at this time?
Do I need to
You enter a plea?
enter a plea?
Yes, ma'am.
Time served.
No, that's not a plea.
Oh.
A plea is guilty, not guilty, or no contest.
On the evidence, not guilty on that.
Okay,
It's not even the same bag.
okay. All right. Anything else prior to bringing the jurors in?
No, Your Honor.
Okay. Ms. Tony, you have any other questions?
No, sir.
Do you wish to have the instruction given about your right to remain silent?
I know my rights.
Yes, ma'am. That's not what I asked. Do you want the instruction given to the jury about your right to remain silent? And I can read that instruction. It's up to you whether I give it or not.
I mean, I don't, it's
Yeah.
not on the same side.
I got no doubt about that either. In every criminal proceeding, a defendant has the absolute right to remain silent. At no time is it the duty of a defendant to prove her innocence. From the exercise of a defendant's right to remain silent, a jury is not permitted to draw any inference of guilt, and the fact that a defendant did not take the witness stand must not influence your verdict in any manner whatsoever. Do you wish to have that instruction given?
No, sir, I'm taking the stand.
Okay, very good. Anything else prior to bringing the jurors in?
No, sir.
Ms. McAfee?
No, Your Honor.
All right, let's bring the jurors in.
Oh, and it's going to be great. This is a train wreck that you can't stop watching. The case itself isn't that interesting. It's simple possession of meth. There's not a whole lot to be proved for the state to prove here.
Once you're in the restroom,
Okay, Whenever they get finished, we'll be ready to go. James, how you doing today?
I'm well, Your Honor, how are you?
Good.
Can I tell them that I wasn't allowed to show them the notarized paperwork?
Ma'am?
Am I allowed to tell them that I wasn't allowed to show them the notarized paperwork?
No, ma'am. And if there's an objection made, we probably ought to come sidebar those objections, okay?
All right. This is Bay County, Florida. I was messing with Mole because he was trying to mess with me. This is Florida. This isn't Canada. That was a bad joke.
Understand this, Tony?
Yes, sir.
Good morning, members of the jury. My name is Morgan McAfee, and today I represent the people of the state of Florida. Today, we're going to be going back to March 31st of 2023. Deputy Cherie Edwards gets called out for a suspicious person on Surf Drive in Panama City Beach, going near cars and houses. And by the time Deputy Edwards arrives on scene, the suspicious person is gone, but the people there are able to give a description of the person and kind of show Deputy Edwards where she went to, which was a public beach access point along Surf Drive, which is still in the eye line of the houses. Deputy Edwards goes over, and that is where she finds the defendant, Ms. Tania Tony, sitting there with her 2 bags. Through the course of her investigation, she ends up searching those bags. And when Deputy Edwards searches the one bag, she finds items such as clothes, women's clothes, things like that. In the second bag, she finds a blue Ziploc bag. And in the blue Ziploc bag, there is like a cellophane wrapper. And she asks Miss Tony, the defendant, what's in this? Because she sees a crystal substance in that cellophane wrapper. And the defendant says that it is methamphetamine. Later, when Deputy Edwards, through Bay County Sheriff's Office, sends that substance to the Florida Department of Law Enforcement, which will be called FDLE. It is the lab where they do the testing of the substances. You'll hear from one of the lab analysts, Paula Vivera, that substance that was sent by Cherie Edwards and Bay County Sheriff's Office that was found on the defendant was in fact methamphetamine. Members of the jury, this is not going to be a complicated case. At the end, the judge will instruct you on what the law is, and I expect that he's going to instruct you that there's 2 things that I have to prove beyond a reasonable doubt. The one is that the defendant possessed a substance, and 2, that the substance was methamphetamine. At the end, after you've seen and heard all of the evidence, I submit that there will be no reasonable doubt, and I will come back before you and ask you to find the defendant guilty as charged.
Just don't whenever you're ready.
Well, I felt like it was an illegal search and seizure. I was at a beach
Objection.
access.
Sustain.
I can't tell them.
Sustain.
Well, I was at a beach access at 3 o'clock during the day, and they said I had loitering and prowling.
Objection.
Sustain.
A word is only as good as a man that can stand by it. On Monday, I asked the jury one question. Has anyone ever had a run-in with the law? I didn't see one person without their hand up. I am not standing here today trying to deny being wrong according to the law. However, I feel as if I need to stand taller than law enforcement when I never claimed to own a badge. Frank McKeithen on,
Objection.
I'm sorry, I can't say Frank Sullivan. I'm sorry, I said.
Your Honor, maybe.
I'm gonna see where she's going with this.
Frank Sullivan, the state attorney, talked Monday about hearsay. When I was booked into the Bay County Jail, I was told I had 2 counts.
Objection.
What do you consider? We can't get audio of this? Like, of what actually happened? There was 2 counts. One disappeared. I mean,
Y'all wanna come forward, please?
She made it what? 45 seconds before the judge told her to come to the bench, like, you got to stop this, lady. Especially, it was not even 10 minutes before. No, it was more than 10 minutes. 10 minutes in the video, but where judge said, no, you can't tell him that you're in prison. You can't tell him why you're in prison. You can't do that. And then she instantly goes into that. Man, this is going to be fun. Also, I cut out all of the jury instructions, which was about an hour and a half worth of video. So if it looks kind of uneven, like right there, judge didn't say bring the jury in. Well, he did say bring the jury in, but then they started talking, and then it just cut right to the opening statements. That's gonna happen a lot because I cut all of that stuff out. Okay, let's go. She has standby counsel. I probably should have said that. It's the lady sitting right behind the defense table. She's wearing a lighter color. I can't really tell what color it is. Might be white, might be like a light pink. I don't know. But she does have standby counsel. She never uses her though.
When I was booked into the Bay County Jail, I was told I had 2 counts. Now I ask you, what happened to the count? Was it just him simply hearsay? What do you consider a controlled substance? Does it not imply control, or would it be black market? The worst drug I've ever been in was methadone prescribed by our government control clinic. The withdrawals lasted for over a month. Mr. Sullivan also asked you if weed or meth should be legal. However, alcohol is the #1 killer. So when I have personally seen countless child rapists walk free.
You're getting into argument now. This is your opening statement. What evidence you think will be produced? You're making argument now, so I'm going to direct you to make your opening statement and explain into that. You'll get a chance to argue later on in the trial.
Okay, so
You can ask what I'm doing. I'm just telling you right now, you're making an argument. This is not the time to make arguments. This is opening statements.
okay, considering the said count was just simply disappeared, I keep thinking back on this day, and I remember having a Ziploc bag, but it was not the color. She has evidence that is a different color than what's in their bag. So just as simply as it can disappear, it can reappear. So I want you to take a close look at their evidence. And I'm not saying that I didn't have a dirty baggie on me, but I have no problem saying I had 2 counts when one of them disappeared either.
You may call your first witness.
The state calls Deputy Cherie Edwards.
Deputy Edwards, come forward, please.
Better here, man, if you would stand by the chair, tell the clerk sure thing.
You do solemnly swear or affirm the testimony you're about to give to be the truth, the whole truth, and nothing but the truth to help you God. I do. Thank you.
Ma'am, you have a seat, speak directly in that microphone. You may inquire whenever you're ready.
Good morning.
Good morning.
Can you introduce yourself to the jury?
Hi, I'm Deputy Cherie Edwards,
And where do you work?
Bay County Sheriff's Office.
How long have you worked there?
3 years.
Were you law enforcement anywhere else prior to that?
Yes, I was.
And where was that?
Jackson County Sheriff's Office and Mariana Police Department.
How long in total have you been in law enforcement?
About 15 years.
What's your current role at Bay County Sheriff's Office?
Deputy Sheriff.
And in all of your law enforcement experience, what kind of training have you had?
I've had crime scene training. I specialize in crimes against children, as well as property crimes and persons crimes.
And as a deputy at the Bay County Sheriff's Office now, what is your current role? What's
Ju-
your duties, I should say?
To enforce the laws by the state of Florida, and to just help the citizens when they call in for assistance and so forth.
When were you working on March 31st of 2023?
Yes, I was.
And briefly, were you dispatched to search drive?
Yes, I was.
Can you give the jury just a kind of vague description of why you got called out there?
I got called out in reference to a suspicious person that was in the area of Search Drive, which is just on the other side of the beach. And the call note stated there was a female that was just acting suspicious, trying to go into cars, into houses.
And by the time you got to Surf Drive, was that person still there?
The person was not at the location I was specifically dispatched to.
Were you able to find that person?
Yes, as soon as I got there, I spoke with the complainants that called in. It was, this is a rental property, like an Airbnb, kind of side by side. And so both parties from each respective house or address was there. And they kind of briefed me on why I was there, gave me a description of the female, and then pointed me into the direction of where she was at.
And where was she at?
She was at Beach Access 18, which is less than 100 yards maybe from where we were located.
And did you go to the beach access?
I did.
And what did you see when you got there?
When I got there, I saw the female matching the description of what they had provided me.
And how was that person? Were they sitting, standing?
They were sitting.
What was with her?
She had 2 bags with her.
Can you describe what those bags look like?
They were like a zipper type bag, and then I think like a drawstring type backpack.
And that was in Bay County?
Yes, ma'am.
How did she appear? What was her manner?
When I began to speak with her, it was apparent that she was under the influence of something. You could tell just by the way she was acting and the way she was talking.
Through the course of your investigation, did you end up searching those bags?
I did.
What was in the drawstring bag?
I found some clothing. I found some credit cards and so forth that were addressed to her, which was indicative that that was her bag. And then I found a smaller zipper bag.
And did you ask her if those were her bags?
Yes, I did, because they were sitting there with her. And so I did ask because, I mean, it's a public access.
Okay. And what did she say when you asked?
She said, yes, they were her bags.
Did you search the zipper bag?
I did.
And what did you find in the zipper bag?
I found a Ziploc bag, like a baggy Ziploc bag.
May I approach?
You may approach.
All right, this is a good time as any for a little quick break. Neil, thank you so much for the super chat. I appreciate it. It's interesting. It's interesting to see the differences set ways court states have. I can't read. Yes, I'll just say yes. It is. No, and we see it every day, especially because we on my channel cover Florida, Kansas, Washington, and Michigan mainly. I do have a couple of North Dakota and Wisconsin courts as well, some in Ohio. But yeah, every state's different. And sometimes you get confused, like, oh, that's not good. They didn't do this. So it's a completely different state. So I do agree. Thank you so much, Neil. I appreciate it. Oh, and another really weird thing. When I was in St. Joseph County just a little over a week ago, and I saw that jury trial, it was a possession of meth case. And the prosecution actually brought the physical methamphetamine to pass around the jury box. I haven't seen that before, but they were passing it around. I was like, I don't know why, but that just seemed really weird to me.
I'm showing you first what's been marked as State's Exhibit 2 for identification. What is that?
This is a blue Ziploc bag.
Okay. And is there anything else in that Ziploc bag?
There is like a smaller baggie inside of it. Well, in law enforcement, we call them jewel bags. They're indicative of like what you'd put illegal substances in.
Okay. And is that the Ziploc bag that you were referring to that you found?
Yes. Yes, ma'am.
And I'm also showing you what has been marked as State's Exhibit 1 for identification. Do you know what that is?
Yes, ma'am. This is considered meth.
Okay. And where was that found?
This was inside the smaller baggie, which was inside the Ziploc baggie.
And are those in the same or substantially same condition as when you found them?
Yes, ma'am.
Aside from being separated?
Yes, ma'am. Yes, ma'am.
Your Honor, at this time, the state would seek to admit items 1 and 2 into evidence.
Any objection?
Show them the picture at the same time.
Any objection?
No.
States Exhibit 1 and 2.
Yes, Your Honor.
States Exhibit 1 and 2 will be accepted in evidence. You may love us whenever you're ready.
I mean, does the objection include this different color bag? Not the same as they have in their pictures.
You'll have a chance to cross-examine the witness.
Okay.
I'll allow the evidence.
Briefly, can you describe to the jury what you do with evidence and how you package it for storage?
Yes. So as she explained, the actual meth was inside of the plastic baggie inside here that was inside this here. The plastic baggie inside here is what is a piece of like Walmart bag. It was tied in a knot, again, indicative of narcotics. We have to separate them. And so at that point, when I got ready to them placing clean gloves on, I extracted the meth out of the plastic bag inside the blue bag, weighed it, and then I prepared it into a baggie of its own, which you can see here, and then I weighed the whole bag. That we have to do prepackaged weights, and we have to do total package weighting. That's our policy at the Bay County Sheriff's Office. And then I take the other two bags, which at this point are considered paraphernalia, and then I do the same thing with those, and we double bag both of them. And again, we do prepackaged weight and we do total package weight. They are heat sealed. Both of them are heat sealed with a machine. They are dated and have my initials at the top. I do an evidence form to complete this process to show that I did collect this process or collect these two items. These items are photographed, and all of this is turned into evidence. And these are both dropped into a secured label, into a secured compartment at the Bay County Sheriff's Office.
So the two clear, completely clear plastic bags that is from you?
It's from me?
Yes, from your collection of it.
Yes, that's correct.
Can I say something?
You have an objection?
No.
You have a chance to question.
Cynthia Edwards, when you found that substance, did you ask the defendant about it?
I did.
And what did she say?
I asked her what it was. That's something we normally ask. Some are truthful, but I wanted to make sure if it wasn't like fentanyl, you know, or something like that, I was going to harm myself or others around me. And she told me it was meth.
And do you see the person in the courtroom today that had that methamphetamine on them?
Yes, ma'am.
And can you identify her by her position in the courtroom and an article of clothing?
She is to the right of me, and she has on a long sleeve white shirt and a black and white top with matching bottoms.
May the record reflect she is identified.
The record will so reflect.
I have no further questions at this time.
Ms. Tony?
It's my turn. Okay. Oh, whenever you were called.
Ma'am, you need to be you can either sit at your table or at the podium,
Okay.
or if you'd like, if you need to go to the witness. You need
Okay, so whenever.
you need to ask, before you approach the witness, you need to ask permission, okay?
Okay, I can just stay here then.
Yes, ma'am.
I know a lot of us would agree that it's kind of an abuse of taxpayer money, but it's a right for a jury trial. I mean, you can take any charge to a jury trial that has, well, I think anything, to be honest, anything that has potential jail time, you can. Even most civil matters, you can too. I mean, it's your right. So there's not really a such thing as abuse of the right to a jury trial, but I know what you're saying. It's a waste of everyone's time. I'd be mad if I was on the jury for this.
Whenever you were called, did the witnesses write a statement or give you a declaration of intent? Because I have 2 declarations of intent that got sent to me in my discovery saying that the law enforcement, it says, I can't read none of my paperwork. Well, I have 2 declarations of intent.
Ma'am, ask questions.
Did the witnesses write statements or sign something stating that they didn't want to pursue any kind of charges?
They don't have the right to not pursue charges on drug charges. That's a state charge.
I'm talking about they said that I was trying to go in people's houses. You were called on the scene by witnesses?
I was called on the scene by a complainant.
Why aren't they here today?
Objection.
Sustained.
Whenever you saw me, I was at a beach access at 3:00 during the day. And whenever I was booked in, I had a loitering and prowling charge. What consists of filing that charge?
Objection.
I'll allow her to ask that question if the witness can answer.
What was your question again?
Loitering and prowling, it states that as long as you don't flee from law enforcement and you show them your ID, that it's not considered loitering and prowling, but yet I've still been sitting in the Bay County Jail almost 18 months on a.
Sustained. Ms. Tony, I have warned you about that.
I don't even know what I'm supposed to ask. And I mean,
You're representing yourself and you.
I know, and I also got sent all this paperwork that's notarized and stuff.
Ms. Tony. Ms. Tony. No. Don't speak under your breath. Everyone can hear what you're saying. If you want to say anything else, you can come sidebar.
I don't even know what to ask her then, because I can't ask about declarations of intent.
Sidebar, please.
The witnesses aren't here.
Whenever you're ready.
Whenever you went through my bag, was I not honest with you about what the product was?
You were.
Was there not another count involved?
There was.
There was. Thank you. That's all the questions I have.
Okay. Any reader
No, Your Honor.
Okay. Can the witness be excused?
Your Honor, if we could have her subject to recall.
Deputy Evans, you're still under the, you're still subject to recall. You can leave the courtroom, just be available if you're called back as a witness.
Yes, sir. I'll be right outside.
Thank you. Ms. McAfee, is your next witness present?
Your Honor, I believe.
Let's go ahead and take a 10-minute break. We have a witness that's coming from out of town. 10 minutes. Let's take a 10-minute break. Remember to leave your notepads in the courtroom. Do not discuss the case amongst yourselves or anyone else. Don't check any media sources. I have to say this every time we leave. I know it sounds stupid. It sounds stupid to me, but I have to do it, okay? If you'll follow the bailiff in the back, and we'll start back in about 10 minutes.
Can I ask a question?
Yes, ma'am, you may. Let's go back on
Can
the
I
record.
read-
Hold on, let's go on the record.
Oh, can I read a
Hold on,
case?
yeah, go ahead. Yes, ma'am.
Sorry, can I read a case law?
No, ma'am, not to the jury.
Even if it was in this court?
No, ma'am.
Okay.
Okay, case?
Yeah, a case.
No, ma'am. If you want to, you can proffer it for the record here, out of the hearing of the jury.
Okay, it was, in your court, and it was, Frank Sullivan, and her name was Tracy Leandra Lynn, which just got settled on 11/18. She was only incarcerated for 1 month. And, she was here for trafficking bong water, and they dropped it down to a possession charge. It was like 454 grams. But But I can't ask the tester, why don't they boil that water down and it still be a trafficking amount? Because you could get a lot back from that. I mean, it would still be like 28 grams or something if you boiled off the water. So I can't talk to the tester about that.
What is the relevance of that? If you want to, if you can answer what's the relevance to it.
Because I know I had a paraphernalia charge, and it's like they throw out trafficking charges, which is a lot of time. I know you guys like to get your time.
It doesn't make any sense. What are you trying to, I mean, what?
They threw it out. She was not even in jail, but for a month. And
That's not
they
relevant. No, ma'am.
dropped it down to a possession charge.
Oh, that's what no, ma'am. That's not relevant to this case.
And why don't testers do that though?
And once again, you have a right to be represented by an attorney at any stage of these proceedings, and I'll appoint Ms. McCarthy to represent you.
I think Judge keeps saying that every time she says something that's beyond dumb. Yeah, I had this one person that was in jail with me that got a charge thrown out about bong water. I'm going to bring that up. Why?
Money you're about to give to be the truth, the whole truth, and nothing but the truth. Oh my God. I do think.
And if you'll have a seat, speak into the microphone, please. Ms. McAfee, you may inquire whenever you're ready.
Good morning.
Good morning.
Can you introduce yourself to the jury?
My name is Pallavi Veera.
And where do you work?
I work for the Florida Department of Law Enforcement, Pensacola Regional Operations Center.
And what is the Florida Department of Law?
It's a law enforcement agency where I work in the crime laboratory part of the law enforcement agency, and it gives services to the local law enforcement agencies.
And how long have you been working as a crime lab analyst?
Approximately 11 years.
Do you have any specialized training or education for your position?
Yes, I have a Bachelor of Science degree in biochemistry and Master of Science degree in life sciences. As a crime laboratory analyst, I underwent an intense training program. It lasted approximately 11 months. It included academics, practical exercises, and supervised casework. Sorry, my cough is coming in. It lasted approximately 11 months.
And have you had the occasion to chemically analyze substances to determine whether the substance is or contains a controlled substance?
Yes,
About how many times?
over 20,000 times.
And have you had the occasion to determine whether a substance is or contains methamphetamine?
Yes,
Approximately how many methamphetamine analysis do you make in a given month?
approximately 50 to 60.
Do you make these analyses as part of your duties as a crime lab analyst?
Yes,
Your Honor, I will send the witness for the voir dire.
Ms. Tony, do you have any voir dire of the witness as far as her qualifications as an expert?
No, sir.
All right, she may be allowed to give her opinion.
On May 9th,
I would bet money that the defendant had no idea what they just asked him. What they just asked her. What's up, Chris Barton? Giant shout out to Chris Barton for the generous PayPal last night. I saw it right after my stream ended. Chris, you are awesome. Thank you so much for that.
2023, did the FDLE lab receive a suspected controlled substance in this matter from Bay County Sheriff's Office?
yes.
All right, I'm going to answer this because a lot of people have been asking. They adjourned it. I don't know who filed it. The judge may have actually done it, but they sent him for competency, the defendant. So they actually pushed his trial back to February or March, but a good couple of months. But they sent him for a competency. Yeah, so he got the adjournment he wanted, just not the way he wanted it.
Your Honor, may I approach?
You may approach.
I am showing you what has been marked as State's Exhibit 1. Do you know what that is?
Yes, it is a heat sealed plastic bag. It contains another plastic bag and it has a crystalline substance in it.
Okay, and do you recognize this?
Yes,
How do you recognize it?
I recognize it by the yellow laboratory sticker, as well as wherever I made an opening, I placed a evidence tape and initialed on it.
Is this in the same or substantially same condition as when you received it?
Yes.
And when you receive an exhibit, what do you do?
Once I receive an item, I take a visual inventory of the item, and then I open it for analysis. First, I would open and take the substance out and weigh the substance, and then I would perform a chemical color test, and then 2 instrumental tests.
And did you perform an analysis on this substance?
Yes.
And what examinations were done on this substance?
I had performed a chemical color test as well as 2 instrumental tests. One is called gas chromatography. Another one is called gas chromatography mass spectrometry.
And based on those examinations, were you able to form an opinion as to what the substances are containing?
Yes,
And what is your opinion?
it contained methamphetamine.
No further questions, Your Honor.
Ms. Tony?
How long ago has it been since you saw the evidence?
Let's see. Evidence was out of my custody on August the 11th of 2023.
You said that you weigh the evidence. Is that correct?
Yes.
Why would your report not have a weight on it?
The report is not showing the weight because there was no threshold weight associated with it. That means a felony weight associated with it. So unless it's a felony weight, we do not put it on the report.
So unless it's a felony amount. So,
Yes, the felony amount.
so you're saying that I have a misdemeanor amount?
Objection, Your Honor.
I am not.
So would you? You said that you do 4 different tests on it.
I performed 3 tests, chemical color test and 2 instrumental tests.
Okay, on this report, it says that you've done 4.
It says gas chromatography, mass spectrometry, gas chromatography, and chemical color tests.
That's not 4?
That is 3 tests I had performed.
And then the chemical color tests also, right?
Correct.
About how much do you think it would take to test all 4 different? About how, for each test, how much does it take?
So for the instrumental test, I would take approximately 1 milligram per mil. And also for the color test, I would take approximately 1 milligram.
What about the others?
2 instrumental tests, I would take 1 milligram per mil. And then I would take approximately 1 milligram per mil, or 1 milligram for chemical color test.
So for all 4 tests, it would take approximately 4 milligrams?
2 milligrams.
2 milligrams.
Correct.
1 milligram for each test, but then it's only 2 tests or 4 tests?
When I perform a chemical color test, I take even less than a milligram, but approximately a milligram, and then I take some sample, which is approximately 1 milligram for the instrumental test. I would perform 1 instrumental analysis, and then I would perform another one to confirm the test.
You said you did 50 to 60 different methamphetamines. That's about how many tests you do a month?
Correct.
And you would be able to see one methamphetamine from a different methamphetamine
Yes.
Or they essentially look all the same?
Methamphetamine as a substance would look the same in, when you put it through the gas chromatography mass spectrometry. It's a specific test. So when you introduce sample into the instrument, it goes through a gas chromatography part where it separates into its components, and then each component would enter into a mass spectrometer, and there it will break down into small pieces, which will cause a fragmentation pattern. And this fragmentation pattern is very specific to that substance. So every time you would put methamphetamine into the instrument, it would break down in a similar pattern, and then it is compared to a known standard.
I was asking about before you tested it, is there not some that maybe are big chunks and then other methamphetamine that you get that are smaller chunks or maybe even powder? Or they all look the same?
They look different, similar, same sometimes.
Thank you. No further questions.
Can you redirect the witness?
Just briefly, Your Honor. Ms. Vera, you said that you recognize that sample in this case based on the label.
Yes.
And are those case specific?
Yes.
So for each specific exhibit that's sent to you, you have a different label?
Correct.
No further questions.
Any other questions for the witness?
Yes. How long ago was it out of your possession?
In sometime in August of 2023.
Thank you.
Anything else for this witness?
No, Your Honor.
Can she be excused?
Yes, Your Honor.
Yes, sir.
Ma'am, you may go about your day.
Thank you.
Ms. McAfee, you may call your next witness.
Your Honor, at this point, the state rests.
All right, ladies and gentlemen, we're going to take our second morning break. We'll take about a 15-minute break and start back at 20 to 11. I'll leave your notepads in here. Don't discuss the case among yourselves or with anyone else. Don't check any media sources or use your electronic devices to find out any more about the case than you know right now. All right. The state has rested. Ms. Tony, you have an opportunity at this time. Do you wish to have an attorney appointed to represent you?
No, sir.
All right. Do you have a motion to make at this time?
A what?
A motion?
A motion?
Yes, ma'am.
I didn't know I could make a motion.
Yes, ma'am.
I would like it to be dropped down to paraphernalia, considering she said that she did not weigh it whenever it was a felony amount. Can we
State's
check the record for that?
State's response?
Weight isn't an element of the simple possession.
I agree. Motion denied. Tony, have you made a decision whether you're going to testify or not?
I don't have no problem testifying or not.
No, ma'am. This is,
I don't mind getting on the stand.
no, I understand that. What the question I'm asking you is, have you made a decision whether you're going to testify? You don't have to testify. You have an absolute right to remain silent. You have an absolute right to testify.
I didn't.
Yeah, that's exactly what he was asking her. This is the part where the defense says, I don't think the state has proved their burden. I am going to move for a dismissal. You know, that's always just like a Hail Mary, but it's always asked. I mean, it's almost expected. And Judge Clark was like, wow, I have pro se's that always ask that. You didn't even know. Her standby counsel should have been like giving her the elbow real quick. Like, no, just ask this. It's going to be denied, but still ask it.
The only person who can make that decision is you.
I had no reason to stay silent.
Okay, so you wish to testify? Sure. All right, if you'll raise your right hand to be sworn in.
Do you solemnly swear or affirm the testimony you're about to give to be the truth, the whole truth, and nothing but the truth to help you God?
Yes.
All right, state your name.
Tanaya Trisha Ellen Tony.
Ms. Tony, you understand that you have a right to testify?
Yes, sir.
You have a right to remain silent.
Yes, sir.
The only person who can make that decision is you. Do you understand that?
Yes, sir.
That once you make the decision to testify and you start testifying, you'll be subject to Ms. McAfee's cross-examination. You understand that?
Yes, sir.
You'll have to answer her questions.
Yes, sir.
You understand that?
Yes, sir.
All right, I'm going to allow you to testify in a narrative form. However, you have to, if there is an objection made, you'll have to stop testifying and let the state make their objection. You understand?
Yes, sir.
Okay. Ms. McAfee, any other questions you'd like me to ask?
No, Your Honor.
Ms. Tony, anything else you'd like to put on the record?
I just want to go over the fact that they didn't weigh it again. And she
Well,
said
ma'am,
it'd
that's
be a
not an
felony
element of this
amount.
case, it's weight. Weight is not an element to the simple possession.
She said she only waited if it was a felony amount.
Well, what she meant was only if it's a trafficking amount. There's no weight element there. The jury will not be instructed about the weight. They're only instructed about the weight if it's a trafficking amount. You're charged with simple possession of methamphetamine. So any weight, any amount that could be tested.
Unless it's paraphernalia. I mean, they could still test the bag.
You're not charged with paraphernalia. You're charged with possession of methamphetamine. And that's all you're charged with. You're not charged with possession of paraphernalia. You're not going to be able to argue it to the jury. Ms. McAfee, you want to say something?
Yes, Your Honor. If Ms. Tony does decide to testify, I do have her certified convictions for her to look over. I have counted 9.
Do you agree with that?
No, I mean, I had prescriptions for baclofen.
Listen to me.
It's one of,
The question is, do you have 9 felony convictions? If you disagree with that and testify to something different, if the state has,
yeah, they had on the controlled substance, it was baclofen, and I showed them my prescription, so that was never.
were you convicted of it?
Charged with that.
Were you
I mean,
convicted?
it on paperwork, it had it crossed out, so I don't know, you guys' paperwork is so bad.
Do you have verified convictions?
Yes, Your Honor, I have them certified.
Okay. You look through them, because if you
I mean, that was baclofen, the possession of controlled substance, and I had a prescription for it. It's not
were
even,
you convicted of it?
they crossed it out, so
I don't know what you mean cross it out. Is there a
they
conviction of
cross
it?
out stuff all the time.
No, ma'am, they don't. On a verified conviction, they do not cross things out. Look at that and see if you agree with those convictions. If not, I'll have to look at them. And if you testify to something different, they'll come into evidence.
No, the possession of controlled substance was baclofen, and I had prescription for it.
Look at it, and then I'll look at them.
What do I need this for? I don't need this.
All right. How many prior convictions?
So you guys' paperwork is.
How many prior convictions do you have, ma'am? Do you agree with? The state's going to ask you that question, and that's a perfectly legitimate question.
MB, the jury's not there yet. They sent the jury out, and this is just their conversation because the state rested. So yeah, this isn't in front of the jury, not yet.
Now, the jury, that if you answer and there's an agreement, the jury doesn't get to know what the convictions are. If not, certified judgments come in. So how many do you have a number of felony convictions that you agree on? Or do you agree with 9?
I mean, I just have a post-conviction relief right now.
That doesn't matter.
He amended
It's a
it.
conviction. How many convictions do you think you have?
I've already told you that I had a
No,
prescription.
ma'am, you haven't
for the
told me
baclofen.
anything. Give me a number.
I had a prescription for the baclofen.
Give me a number. I mean, do you agree you have a felony conviction?
I don't know. He amended my motion, so
Ma'am?
he amended
You're
my
talking
motion.
nonsense. Do you have you ever been convicted of a felony?
Yes, I've been to
How
prison.
many?
Well, he amended my motion on that, so I mean.
Do you agree with 9?
No, I mean, I don't.
How many do you think you have?
I had a prescription for the baclofen. They crossed it
They
out.
did cross it out. So I'm
Yeah.
looking right here. 1, 2, 3, 4. That's 1, 2, 3 on case number 21, 2210. Nope. Yeah. Oh, there's unlawful. There's that 5 counts of unlawful possession of a stolen debit or credit card.
And for the record, I did get an amended motion on this, so.
I could care less about that. These are the ones you're going on once you pled to. That's 1 count of possession of heroin, 1 count of possession of methamphetamine, 1 count of possession of a controlled substance. 1, 2, 3, 9. Once again, ma'am, do you agree with 9 convictions or you do not agree with it?
The controlled substance was baffling, so I don't agree with it.
How many possessions do you think you have?
I don't know, the post-conviction relief he amended, so
Well, I've tried the best I
I had
can.
a bunch of misdemeanors for marijuana pot and those disappeared, so I can never find those on my record. Or whenever they put a pound in my trunk.
Ma'am, I've
Didn't show up.
tried my best. So if there, and I can see these are certified, it looks like 9 counts to me. So if you testify to something different, they'll come into evidence. And once again, you have a right to be represented by counsel. Anytime you like to.
Counsel doesn't know my past like I do. You can defend me the same.
All right, anything else? We got what, 5 more minutes? All right, do y'all need to take a break?
No, sir.
Did I, did I not, the jury instructions over there? Oh, they're right here. All right, we can go off the record. You've been given a copy of the jury instructions, haven't you?
I'm sorry?
The jury instructions? You have a copy of those from Ms. McAfee?
No. I think so.
And we'll have a charge conference after you rest your case. Do you plan on calling any other witnesses
Me?
besides yourself? Yes, ma'am.
I was by myself.
Okay, very good. All right, well, what did I say, 20 till?
You said,
Got 5 more minutes.
break, and that was at 10:27.
So, yeah, we got about 5 more minutes. Yes, Tony, you may call your first witness.
I don't have anything.
Are you going to call yourself?
I mean, I just want to make it.
Oh, Miss Tony, hold on. Yeah, do you wish to call yourself as a witness?
No, I don't want to testify. I don't think, because I've already
Okay.
said everything I wanted to. I don't see no reason to.
Okay, do you wish?
I do have a question.
Okay, come sidebar, please.
Okay.
Miss Tony, you can call your first witness.
I go myself.
Okay, if you'll come to the witness stand, remain standing. Raise your right hand.
You do solemnly swear or affirm that the testimony you're about to give to be the truth, the whole truth, and nothing but the truth to help you God.
Yes, ma'am.
Thank
You
you.
may have a seat. You'll state your name. Just have a seat.
Tanaya Tony.
I am going to allow you to testify in a more narrative form. However, you will be subject to cross-examination and also subject to objections if they're made. All right, ma'am, you may begin.
Okay,
Before she starts, Joel, I said something kind of similar to that earlier, where I just thought she's bored, she's in jail, so she decided to take this to jury trial. You know, she's already in jail, and this isn't really going to impact her sentence too much, or whatever she's in jail for already. I may have done the same thing. I have no idea. I don't know no idea what's going on. But you know, if the options are sitting in jail doing nothing, and having fun in a jury trial, I would take jury trial.
I don't really have that much to say, except for, like I said before, if you can make an evidence disappear, you can make anything reappear. And I was booked in with 2 counts. And I remember the crystalline substance I had, and it was not big old chunks like that. And the color of the bag, which I had to testify in order for me to get the picture, it's a different color bag even. That in that sealed thing, the Ziploc is blue, and that one was clear. Just, okay. So that's really all I had to say. It's about a reasonable doubt, and the doubt is,
That's argument at that time.
okay.
All right. Any other questions?
Can they see both the bag and the picture?
What would you like to introduce?
The plastic bag and the picture.
Is the plastic bag already in the evidence?
Yes, Your Honor.
Or it's already in the evidence, and you want to introduce that picture in the evidence?
Yes,
Okay.
and I want them to see both of them.
If you'll lay the foundation for the picture, please. If you want to give that picture to her, Ms. McAfee. All right, if you want to lay a foundation for that picture to come in?
Lay a foundation?
Yes, ma'am.
Okay. I mean, they don't get to see it?
They don't get to see it until it comes into evidence.
Oh, okay. I would like this picture to be in evidence.
But if you'll testify to what the picture is and.
Okay, this picture is a clear Ziploc with a blue strip on the top.
Any objection to coming in?
No, Your Honor.
All right, this will be the defendant's exhibit 1. And would you like the jury to see that at this time?
Yes, please.
Deputy Dexter, would you take that picture and publish it to the jury? And then when it gets to Mr. Ashley, in the very back, when it gets to you, Ms. Tone, when it gets to Mr. Ashley, you can begin your testimony again.
Can they see the Ziploc that they have of the evidence?
What exhibit is that?
I believe it's Exhibit 2, Your Honor.
Would you like to publish Exhibit 2 to the jury?
Yes, please. Can you please take a look at the color of the Ziploc bag?
That's defendant's exhibit number 1. And for the record, the jurors are looking at state's exhibit number 2. Is that correct?
I believe. Yes.
Any other testimony, Ms. Tony?
I mean, that's not the same bag, but
Okay. Any other testimony? All right, Ms. McAfee, you may cross-examine.
Ms. Tony, have you ever been convicted previously of a felony?
yes, ma'am.
How many times?
I mean, it was just one time, but
How many prior felonies have you been convicted for?
the one crossed out or not?
I just need a number.
Probably 8, but it was a one time, and I have a post-conviction relief
Your
on
Honor,
that.
this time the state would seek to introduce the evidence for 5 convictions for 9 prior felonies.
Will be accepted into evidence. And for the record, I believe Ms. Tony's already seen those.
Your Honor, that'd be composite 3.
That'll be state's composite 3.
So Ms. Tony, on March 31st of 2023, you had methamphetamine.
I had a paraphernalia amount. Yes, ma'am.
Of methamphetamine.
Yes, ma'am, of paraphernalia.
I'm just asking you.
Dirty
yes, no
bag. It was a
question,
dirty bag.
Whether you had methamphetamine that day.
I've already agreed to that. A paraphernalia, it's a misdemeanor. Yes, ma'am.
That's not what I'm asking, but all I'm asking is whether you had methamphetamine that day. That's a yes, no question.
Yes.
Did you have methamphetamine on that day? Yes. All right, state rest. You just admitted to it. Why are you on the stand?
Other questions?
Anything else? I mean, have a seat. You can call your next witness, Ms. Tony.
I mean, I was the only one there. so-
Okay. Do you rest your case? Do you
Yes.
rest? All right.
Yes, yes,
And you'd
sir.
have a seat in your rebuttal?
No, Your Honor.
All right. Gentlemen, we're going to take a short break. We'll come back at 10 hours in the courtroom.
All right, this is closing arguments. They might, I think, well, I don't know why I paused it. Let's go. Closing arguments are next, though. They might have their, I think I took out the jury instructions. I think I took that out, so.
Both the state and the defendant have now rested their case. The attorneys, Ms. McAfee and Ms. Tony, will now present their final arguments. Please remember that what the attorneys say is not evidence or your instruction on the law. However, do listen closely to their arguments. They are intended to aid you in understanding the case. Each side will have equal time, but the state is entitled to divide this time between an opening argument and a rebuttal argument after the defense has given its closing argument. Ms. McAfee, whenever you're ready.
Members of the jury, earlier this morning, when I was in front of you, I told you that it would not be a complicated case. It would be a pretty straightforward case. And I said that at that time, I would come back before you and ask you to find the defendant guilty as charged. In a few moments, the judge is going to instruct you on exactly what throughout this trial I had to prove the charge of possession of methamphetamine. And I expect that he's going to tell you that I had to prove two things: that the defendant possessed a substance and that the substance was methamphetamine. Going through the evidence that you've heard and seen today, when we're talking about possession, there's been plenty of evidence, I submit to you, that the defendant possessed methamphetamine. She had it in the bags that she had with her. You heard Deputy Edwards say that they were in fact her bags, that she had credit cards or some other form of ID in those bags. The defendant herself admitted that she had methamphetamine on her, that she had the substance. She knew about the substance, she possessed it. Additionally, you heard scientific evidence that the substance was in fact methamphetamine. You heard from FDLE lab analyst Paula Vivera that when she tests methamphetamine, which she does about 50 to 60 times a month, you heard her go through that entire process, and that her opinion, based on what she's done in her training and her being in that position for 11 years, is that that substance was in fact methamphetamine. So you have the defendant saying that it's methamphetamine, and you have a scientific test backing up that it was methamphetamine. Today, you've also heard some other things. You've heard things about paraphernalia and weight, perhaps. But when you're looking and what you're doing in the jury room, you'll be going through the elements that the judge instructs you. And in those, you'll find, I submit to you, that there is nothing that asks about weight, and there is nothing that talks about any other charges other than the possession of methamphetamine, which the defendant has confessed to in front of you. You don't need to get distracted by all the other things that have been brought up. This is straightforward, and it'll be laid out right for you. I submit to you that based on the evidence that was presented and the defendant's own testimony, there is no reasonable doubt that on March 31st of 2023, the defendant possessed methamphetamine.
Ms. Tony, whenever you're ready.
I never came in here saying that I didn't possess something, but it does matter about weight, because it is the difference between a misdemeanor and a felony.
Objection.
Sustained. I'm going to ask you not to consider that argument.
Even their cop, their law enforcement officer said that I was honest with her. And I'm going to remind you about the evidence. The bags weren't even the same color. So just as easy as it can disappear, it can reappear. And I know what I had. It was not big chunks like that. So.
When you get selected for a jury, there's a lot of things that the state asks you to give up as part of this, and that's one of those is bias. But one thing that you're never asked to give up is your common sense. You'll see the bag in evidence, it'll go back with you. You'll see the bag and the cellophane wrapper, and you'll see that it's the same bag and cellophane wrapper that's in the picture. You can use your common sense. You'll also see the methamphetamine. Again, you're hearing things that are not pertinent to this case. You're hearing things about weight. Nowhere in the elements will you find that the state had to prove that the substance was a specific weight. When she's talking about paraphernalia are things that are like pipes or scales or things of that nature. That is not something that she has been charged with. All that is in front of you is the possession of methamphetamine. She's arguing about all those different things that she hasn't been charged with, things that are not part of the element of this crime. But the one thing that she isn't arguing about is that she had methamphetamine with her that day. And ladies and gentlemen of the jury, that is the only thing that you were going to be asked to determine. This is a straightforward case, and I ask you to bring back the only just verdict in this case, and that is to find the defendant guilty as charged.
All right. Gentlemen, it's my understanding you have reached a verdict. Is that correct?
All right, we'll move on to the verdict. And I got to say this real quick. Generally, when Judge Clark does a jury trial, when the case is over, the jurors are deliberating, he will stop the live stream and he'll start a new one when the jurors come back. The jurors took 5 minutes to deliberate this case. 5 minutes. The total time between the jurors walking out and coming back was 12 total minutes. So it took them longer to walk to whatever room they were going to and come back than it did to decide their verdict on this case. And I don't think I need to spoil it, but I think we all know what they're about to say here. All right, let's finish this one up.
Correct. Who's the fourth person? All right, sir, if you'll present the verdict to Deputy Dexter.
Should have given me two papers.
All right, thank you. Very good. All right, Ms. Tony, if you'll stand up, please. Madam Clerk, if you'll publish the verdict.
In the Circuit Court of the 14th Judicial Circuit in Fort Bay County, Florida, State of Florida versus Tania Tricia Ellen Tony, case number 23 CF 1251. Verdict. We, the jury, find as follows as to the defendant in this case. Count one, the defendant is guilty of possession of methamphetamine. Dated December 5th, 2024, four-person, Charles Ware.
Madam, Ms. Tony, you can have a seat. Madam Clerk, if you'll poll the jury, please.
Yes, sir.
Ms. Tony, at this time, I think she's been held without bond in this. Is that correct?
I believe that is correct, Your Honor.
And Ms. McAfee, you prepared for sentencing?
Yes, Your Honor.
Ms. Tony, you prepared for sentencing at this time?
Yes, sir.
All right, do you wish to have an attorney to represent you at this stage of the proceedings?
To be sentenced?
Yes, ma'am. Yeah, you just have a right to be represented by an attorney. If you'd like to have one, I'll appoint Ms. McCarthy at this time.
Yeah, the biggest waste of money is that lab analyst. That lab analyst leaving her lab, driving down here to testify for, 10 minutes total, and then going back. She's probably the most expensive person in this entire thing next to the judge, and that might be even close.
It's up to you. It's totally up to you.
I don't know what she could do for me.
I'm just giving you that option, ma'am.
Okay.
So you wish to have her appointed, or you
I
want to?
mean, I don't think so.
Okay, that's up to you. All right. Ms. McAfee, what's the state's argument at this time?
Your Honor, the state would be asking for 36 months in the Department of Corrections She had been previously sentenced to 18 months for those 9 felonies. Previous to that, she'd been released from prison on 12/28 of 22, almost 3 months later, she picks up these same drug charges. Clearly, she was sent to prison on that case for a violation of probation. She had violated probation within 2 months of being placed on probation. Clearly, she is not amenable to probation. Her score sheet, which I will show her, does have a score. She only has 26.4 sentence points, but that makes her eligible for prison, and she has already been once for 18 months for similar charges.
All right. If you want to present her the score sheet. Ms. Tony, any argument you have or anything you'd like me to consider before handing down sentence?
I mean, I wasn't on probation. I didn't violate this time, and I don't even score out for prison.
Okay. Anything else you'd like me to consider?
To have mercy on me.
Okay. All right, can I see the score sheet? Are you satisfied with that score sheet?
26 points. Yep. These I didn't ever, they just gave me time served because I did 84 days on it.
Yeah, these are not the current, this is your history.
I know,
That's your prior records.
I know, but they just gave me time served. They were trying to give me a year probation on there, and I told them, what does it carry? And he said 90 days, and he said, you've done 84 times served, so I
Your
don't
Honor,
feel like that should be on there.
Her
Well, the-
complaint is that
Yeah,
the
I was never
two-
convicted.
she was given time served on 2 misdemeanors, and she's saying that those aren't convictions,
There weren't convictions, the reckless driving and
but they are in the court.
If you got time served for them, they'd have to be convictions.
well, I was just already in there.
Yes,
So
ma'am.
they just gave me time served on them, but
Yes,
he's
ma'am.
trying to give me a year probation.
That's what happens. All right. How much credit does she have for time served?
I had 402 days.
I had over 500. It was almost 18 months.
When was she arrested on this charge? I know.
It would have been March 31st of 23, and then she bonded out, and then she had picked up new charges. I think she had been in jail this last time since May of 2024. I believe that was 210 days in this last stint. There was a stint that was 91 days, I think was her original. And
Let me
then
look at this. Madam Clerk, can you look and see when was she arrested on March 31st?
She was arrested March 31st.
And then when did she bond out?
First time she bonded out. Received the bonds on July 3rd of 2023.
July 3rd?
Then August.
Hold on just a second.
Sorry,
All right, and then when was she rearrested?
August of 2023,
August 20th?
August 28th, I'm sorry.
August 28th? And she's been in custody ever since then?
No, Your Honor, I see another bond that was.
No, I never got another bond. I got time served on the reckless driving and stuff. That was like,
I'm talking about this case right here.
yes, I know, but I never got another bond. The bond was just still good because it was a misdemeanor.
oh, they may
But I
not have
still did
revoked her
time
bond.
served. They didn't revoke my bond.
I showed that there was another bond on October 30th of 2023 for $3,500.
That was whenever I was arrested.
Were you released after August?
For this case.
Were you released again?
I did time served on the misdemeanor.
Don't tell me time served again. I'm talking about this case right here.
Right.
You
I got
were
one
arrested
bond.
on March 31st. You bonded out on July 3rd. Evidently, you got rearrested on August 28th of 2023. Have you been in jail since August 28th of 2023?
Yes.
No, Your Honor.
Okay,
Because she picked up new charges in May of 2024, so she was out.
okay. When did she bond out?
Your Honor, there was a motion to reinstate bond, and then the bond was reinstated at 3,500, and she posted bond on October 30th.
October 30th. So she spent from August 28th to October 30th.
And then she was,
Okay,
then she was back in custody May 10th, 2024.
May 10th. And she's been in custody ever since. Is that correct?
Yes, Your Honor.
Today's the 5th. I got 470 days. How many do you have?
I had 402, but I'll concede to.
Hold on, Will. Let's make sure we're right.
I had right at 500, so.
It was August 28th to October 30th. Is that correct? I get 368 days. 368 days. What'd you get? 402?
Yeah.
This is what
From 2023, and then I got bonded out in July.
I've got 95 days from March 31st to July 3rd of 2023. That's 1 day in March, 30 days in April, 31 days in May, 30 days in June, 3 days in July. And then from August 28th to October 30th, I have 60.
Don't worry, Colleen. You missed about 4 seconds of the video because that's all it took the jury to deliberate. It was really quick, but it was guilty.
3 days. 3 days. Actually, it'll be 4 days in August, 28th, 29th, 30th, and 31st. That's 64 days. That's 369. And then from May 10th to December 5th, I've got 22 days in May, 30 in June, 31 in July. August is 31, 30 in September, 31 in October, 30 in November, 5. Oh, hold on. Hold on. No, that's right.
And then just, and then to December 5th, right?
Yes, ma'am.
I thought it was almost 500 days.
All right, while we're watching Judge Clark attempt to do math, I'm going to let this video play out. Thank you guys so much for hanging out with me today. This is almost over. There's only about 5 minutes left of the clip. So, yeah, this one was fun. I don't really have anything else to say. It was fun. And, yeah, have a great rest of your day. I will be live tonight as normal. This was going to be my video tonight. Just court was really slow this afternoon, so I decided to throw this out here now. So now it's time to respond to Heather because she's texting me. But after that, well, before that, you guys have a great day. Please hit that like button on your way out. I would very much appreciate it. And yeah, don't do anything dumb this weekend. You don't want to end up on my channel. It's about all I got. That's all I got, guys. Otto, thank you so much for the super sticker. I appreciate it. You love the late edition stickers, and I always appreciate it. Thank you so much, Otto. Yeah. Let's see, where are we at? We're at 118, and this video is 121, I believe. So there's less than 3 minutes left.
I may have, I got my numbers based on the Bay County Jail inmate report, but it may not have revoked release in certain cases. So that may be why my number is a little bit higher.
The easiest thing to do is to count the days. Don't
Yes.
worry about somebody else's.
I got 369 when I just added it.
That's what I've got. All right.
I got close to 500. It was like 407 days.
I don't see how you get
And
that.
I counted the days from off the calendar and my sick calls.
Did you get the days you were out of custody? Did you count those?
Yeah.
You don't get to count those.
All right, I got you, Maul. I don't even remember the order though. It's what is it? Soft kitty, pretty kitty, little ball of fur, happy kitty, sad kitty, purr, purr, purr. Yeah, I know I messed that up, but you're welcome. And you guys are all welcome for my angelic voice. All right, you guys have a great rest of your day. Thank you. Bye.
I mean, no, I counted those as not being incarcerated.
Well, I've counted it, and
I
it
was
looks
only out for like 2 months.
no, it looks like you were out from
And then they
October to May.
no, they rearrested me with the reckless driving. They didn't revoke my bond.
Then you don't get those days.
That-
They didn't.
But I'm saying I was incarcerated.
I agree with you, but you don't. If they didn't revoke your bond, you were still out on bond.
No, I'm saying I was incarcerated, but they didn't revoke my bond because it was misdemeanor.
I understand that. So you don't get credit for those days. All right.
I
So
don't get credit for those days, even though I was incarcerated.
you were incarcerated on this case, ma'am.
I know, but it would still be for that case.
No, ma'am. All right. What I'm going to do, ma'am, Miss Tony, a jury of your peers has found you guilty of possession of a controlled substance. I am going to adjudicate you guilty of possession of a controlled substance. I'm going to sentence you to 42 months in the Florida Department of Corrections. I'm going to give you credit for 369 days time served. I'm going to assess fines and costs of $628. Those include discretionary costs of $2 of local law enforcement education, a $65 assessment of additional court cost, a $50 drug abuse trust fund payment, and a $200 discretionary fine. Those fines and costs are reduced to a civil judgment. There's no restitution outcome in the case. Is that correct, Ms. McAfee?
That is correct.
And I'll need an order to that. Ms. Tony, you have 30 days to file your notice of appeal. If you wish to appeal your judgment sentence, if you'd like to have
File that right now?
ma'am, if you'd like to have an attorney to represent you,
Yes,
may-
ma'am. Can I?
if you wish to have an attorney to represent you, one may be appointed to represent you at no charge. Ms. Tony, you have 30 days to file your notice of appeal. If you wish to appeal this judgment sentence, good luck to you. You need to stand up and be fingerprinted.
And Your Honor, at this time, the state would consolidate case number 24-1593 CF.
All right, I got to say one more thing. I have to. If you wish to appeal this, but I might remind you, on the stand, you said that you had possession of meth and you're charged with possession of meth. So good luck in your appeal. Okay, you guys, I'm out.
All right, she's released from whatever bond she's on that case.
And Your Honor, we'd have to be appointed for appellate.
I'll appoint the Office of Regional Counsel for appellate purpose.
Thank you.
Thank you, Ms. McCarthy. Ms. McCarthy, thank you for being present all day today.